Let me just tell you what a huge honor it is to have our Constitution Day speaker here today. You know that he did this speech for you once, and the technology declined to bring it to us. So he is here in person. How fabulous is that? You also know that Senator King served as the 72nd governor of the great state of Maine. And during his 2 terms in the Blaine House,
You almost did White House.
I did. So the first question I asked him today was, are you Speaker of the House yet? It could happen. So the things he did while he was in the Blaine House included economic development, job creation, and the appointment of some of the very best justices ever appointed to any of the courts in the state of Maine. When he was reelected in 1998, he was reelected by one of the largest margins in Maine history. And in January of 2013, he was sworn in as Maine's first independent United States Senator, filling the same seat once held by Edmund Muskie, George Mitchell, and Olympia Snowe. It's an extraordinary history. His interest in cybersecurity has brought him to Maine law. He answers the call every time I pick up the phone, and he never mentions the meatloaf. So he has also told me that he is ready and willing to take questions when he is done. Senator King, we are delighted to have you. Thank you very much. The floor is yours.
Thank you. I am announcing right now my candidacy for Speaker of the House. You should know that there's no rule that the Speaker of the House has to be a member of the House. And on Wednesday night on MSNBC, Jamie Raskin, one of the leaders in the Democratic Party, floated my name. He said, what we need is a unity speaker that the Democrats and Republicans can come together. And he said, my suggestions are Liz Cheney, Mitt Romney, or Angus King, which I thought was hilarious. I don't think it's going to happen. In fact, it's not going to happen. Okay, Constitution. Before you talk about a constitution, let's talk about government. Why do we have a government at all? Throughout history, there's been government, thousands and thousands, tens of thousands, hundreds of thousands of years. There's been some structure of government. Generally, it's all about security. And in fact, if you look at the preamble to our Constitution, the two basic, there are a couple of provisions in there, but two of the heart are ensure domestic tranquility and provide for the common defense. Ensure domestic tranquility, that's the cops, and provide for the common defense, that's the army. So basically, the whole premise is to create an institution that will protect you, will protect us. Why? Because we're human beings and we have emotions and we have tendencies toward violence. Anybody that doesn't think it's in our DNA, I challenge you to look at 2 3-year-old boys in a sandbox with one truck. Okay? So you create this entity to protect you, to keep you safe. The problem is, by doing so, you're giving power to someone else, and the danger is that they'll use it to abuse you. You see what I'm saying? And that's really the central challenge of political science. I'm going to teach you all you need to know today about the Constitution and political science. It's a bargain. But the question becomes, if you create an entity and you give power to it, how do you keep that entity from abusing you? The Romans put it in a question. This is all you need to know about political science, this question. Quis custodiet ipso custodes? Quis custodiet ipso custodes? What that means is, who will guard the guardians? Who will guard the guardians? And that the Romans recognized this because it's human nature. Here's the problem. It's human nature. If you give people power over other people, it will be abused. There was a philosopher in England in the 1800s named Lord Acton. and he gave one of the most profound observations on this point. Here's what he said: all power corrupts, and absolute power corrupts absolutely. The more power you give, the more dangerous it becomes. There was a famous experiment, I think it was at Stanford, 20 or 30 years ago, where they divided the students into prison guards and prisoners. And after 3 or 4 days, these were just Stanford students. The prison guards were grossly abusing their colleagues. Even though it was play acting, it was, in fact, those kind of experiments have now been banned because of this awful result. There have been experiments of people having a dial where they think they're shocking someone to make them tell the truth. It's supposed to be all pretend. And they found that people will just turn that dial up. So power corrupts, absolute power corrupts absolutely. How do you guard the guardians? Our Constitution is probably the most, I believe, sublime answer to that question ever devised, because the framers, the people that wrote it, they understood two things: history and human nature. So what they did, I'm going to give you a visual. The history was George III, King of England, all power, and abuse of that power. So they wanted to try to come up with some mechanism to avoid the potential for abuse. They knew they needed a government. They'd had the Articles of Confederation. A lot of people forget the Revolutionary War was over in the early 1780s. The Constitution didn't come for 6 or 7 years. There was this period in between where it was essentially the states were on their own, and they realized it didn't work. They needed more of a government. So what was the answer that they gave? Well, I'll demonstrate. This is George III. Concentrated power. Okay? All the power is right here. This is the Constitution. So, concentrated power goes in the Constitution, and it does this. Well, you see that? You get the point? It divided the power up. Look, here's the Senate. Here's the House. Here's the veto. Here's the 2/3 override of the veto. All the herky-jerky, cumbersome techniques in the, you want to see that again? I've got another. All of these techniques are designed to distribute power so it can't be abused. Here we go. By the way, Mary said to be sure and tell you that she grew these cucumbers. Let's see if we can do it again. Here we go. Oh, didn't go that time. There. Divided power. Regular elections are part of the division of power. The division between the House and the Senate, the President, the Supreme Court. Oh, let me look for judicial review. That's an important check, right? Let me look. Where is it? It's not there. There's nothing in the Constitution about judicial review. Judicial review, as you probably know, wasn't invented until about 20 years later in the case of Marbury versus Madison, 1803. So judicial review, the idea that the Supreme Court could declare acts of Congress unconstitutional, wasn't in the Constitution. By the way, I'm going to talk about originalism. That creates an interesting problem for originalists, doesn't it? Originalists say you can only do stuff that's actually in the Constitution, and nothing about judicial review. That's kind of I'd like to run that by Kavanaugh sometime. One of the main checks is elections. And by the way, do you know when the presidential election is every year? Here, I'm going to teach you something that very few other people in Maine know. If you memorize this, you can amaze people at parties this weekend. Presidential election is the first Tuesday after the first Monday in November of every even-numbered year equally divisible by 4. How about that? The first Tuesday after the first Monday in November in every even-numbered year divisible by 4. Now I can simplify it for you. The first Tuesday after the first Monday in November of every year, there's a Summer Olympics. Get the same result. So they divide the power, and they divide it so it's so complicated. Their whole thing is it's going to be hard to abuse people. It's a check on power itself. But when they wrote the Constitution, when they finished, they weren't satisfied. They were very concerned about the potential for abuse, even with all these checks and balances. If a majority got a hold of the whole system, they could still take advantage and trample individual people's rights. So they passed the Bill of Rights. And I've always thought of the Bill of Rights, the first 10 amendments, as a kind of force field around each of us as individuals. So the Congress can do whatever they want. They can follow all the procedures. Both houses pass it. The president signs it. But if it impinges on your right to free speech, it doesn't work. That's what the First Amendment says. And of course, basically the other amendments about search and seizure and guns in the Second Amendment. So the Bill of Rights is kind of belts and suspenders. You have the structure which is supposed to defend you, and then you have the Bill of Rights, which is an additional set of protection. Now, I don't like to read things, but I'm going to read you this because I think it's so apt. The 51st Federalist. By the way, the Federalist, one of the most genius-inspired bits of writing, Hamilton, Madison, a little bit of John Jay, but mostly Hamilton and Madison. And you have to excuse me, ladies, because we weren't as enlightened as we are now. So I'm going to read you what Madison wrote, but you're going to hear men and women, okay? But what is government itself but the greatest of all reflections on human nature? Just what we've been talking about. If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. You follow, Madison? If we were angels, we wouldn't need any government because there wouldn't be any danger from one another. And if we had angels governing us, then we wouldn't have to worry about controls because there's no problem with abuse. But then he goes on. In framing a government which is to be administered by men and women over men and women, the great difficulty lies in this. You must first enable the government to control the governed. That's the safety part, right? And in the next place, oblige it to control itself. A dependence on the people, that's the election, is no doubt the primary control of government. But experience has taught all of us the necessity of auxiliary precautions. That's all this. Auxiliary precautions. That's what our Constitution has answered this question. Now, having said all this, it's fragile. Our system is ahistorical. It's an anomaly in world history. If you think about world history, you read about pharaohs, kings, dictators, emperors, autocrats of one. That's the norm in world history, is one person in charge, a warlord, whatever. You can go back, the chief of the tribe, where you go back all the way into prehistory. So what we're doing, trying to govern ourselves as the public, is very unusual. And it's not guaranteed. We're a 200+ year experiment in human history. And Americans we all tend to have a short historical memory. We think the way things were yesterday is the way they're going to be tomorrow. But it's not guaranteed. It's, as I say, our system is an anomaly in world history, and it's fragile. I take you back to 2020. And I don't think people realize what a close call we had. Because if it hadn't been for half a dozen Republican public officials who stood up to significant pressure, there's no telling where we would be now. What if Mike Pence that day on January 6th, the vice president of the United States, who's charged with opening the ballots of the electoral process, had said, I'm not going to count these votes from Arizona because of contested election results, even though they'd been certified by the legislature and the governor. What if he had done that? I don't know where the hell we'd been. I don't know what we would have done. The same thing goes for Brad Raffensperger in Georgia. What if Brad Raffensperger, on that famous phone call with President Trump, had said, oh, I think I can find those 11,000 votes? So the point I'm making, and there was a Republican election official in Wisconsin who voted to certify the Wisconsin elections, and he had a lot of pressure not to do so. There were members of various legislatures that had pressure to overcome the vote in their state and essentially change the results. What worries me is, can we always count on the Mike Pences of the world or the Brad Raffensperger? In other words, having the right person at the right time who's going to do the right thing? That's worrisome to me. The system is a really good system, but it still has vulnerabilities in terms of who the people are that are in those positions. And I think that's something that we have to keep in mind as we think about where we are in terms of the role of democracy. By the way, the framers were pretty suspicious of democracy. It's really interesting looking at all these pieces of cucumber on the floor here that there's only one not small, but one piece of the whole structure that was elected by the people when the Constitution was passed. That was the House of Representatives. The Senate, until 1916, was elected by state legislatures, wasn't elected by the public. The president, this is really interesting, the president was elected by the Electoral College, as we all know. And if you go back and read the 68th Federalist, it's Hamilton explaining the Electoral College. And the way he explains it, it has never worked that way. The Electoral College was designed to be a kind of council of elders, and the states were to select these wise, thoughtful people who would then select the president. Well, as you know, it hasn't worked that way. It's become, the election, and then you have electors, and then they elect the president. But again, the point I'm trying to make, and by the way, nobody elected judges. So the framers they believed in the public's having a role, but it wasn't entirely. They wanted, as I say, the only popularly elected part of the whole U.S. government at the time of the adoption of the Constitution was the House of Representatives. And of course, we talk about democracy and elections. Part of the history of America has been, I've always thought of it as a series of concentric circles. Because when the Constitution was passed, who could vote? White, male property owners. Now, sometime later, they relaxed the property owner piece. And then at the time of the Civil War, after the Civil War amendments, Black people could vote. Women couldn't vote until 1920. Eleanor Roosevelt couldn't vote when she was a young woman growing up in New York, in her 20s. And people often forget that. We sort of take for granted. So the circle of who's included has always grown, which I think is a very positive thing. Now, let me talk about how you interpret the Constitution. And the sort of theory that's in vogue these days, at least at the Supreme Court, is something called originalism. And originalism is a reaction to what conservatives in the 80s thought was the court writing laws that didn't exist, inventing rights that didn't exist. So originalism is a deceptively simple theory. It says, if you're trying to figure out what the Constitution means, you go to the text itself, the words that are on the page. And if that isn't clear, you go to what were the framers thinking at the time? What was the understanding in 1787 in the case of the Constitution, the Bill of Rights, or 1868 in the case of the 14th Amendment? In other words, that's your test. Anything else is judicial lawmaking. It's bullshit. Here's the problem. Anybody here ever in the Air Force? Any of you ever in the Air Force? Here's the problem. The Air Force is blatantly unconstitutional because Article 1, Section 8 specifically says the Congress shall have the power to raise and pay for an army. The next section, the Congress shall have the power to raise and pay for a navy. Period. Nothing about the Air Force. It doesn't say the Congress shall raise armed forces. You could interpret that to say, okay, well, we have other kinds of weapons. No, it says Army and Navy, no Air Force. Okay, so it fails the first prong of the originalist test because it's not in the Constitution. Okay, so was it in the minds of the framers when they wrote it? 100 and some odd years before the Wright brothers? You see what I'm saying? Now, that's a fairly easy one. How about due process? What does that mean? What did that mean in 1787? Did it mean that a person could be sent to jail for the rest of their life without a lawyer? Because that was the rule in the United States of America until the 1960s. Would anybody argue that it's due process to put somebody in jail or execute them without having a right to counsel? So these, Army, Navy is pretty clear. A word like due process is a word that has got to be interpreted in terms of the times. And here's an example. Loving versus Virginia. Until the 60s, it was illegal. It was illegal. It was a crime in many states to marry a person of a different race. It was against the law. It's called anti-miscegenation laws. They were all over, particularly in the South, but in many other states. So a case was brought, Loving versus Virginia. The Lovings were a couple in Virginia, and the Supreme Court said, no, that's not due process. That's not consistent with the equal protection of the laws. Well, okay, was there anything in the Constitution about interracial marriage being okay? No. Was it in the minds of the framers at the time? No, because we know it wasn't, because there was 100 years of anti-miscegenation laws. So it fails the due process. It fails the originalist test. The same thing with integration of the schools. Equal protection. To us, it's obvious. It's not equal protection if you have black schools and white schools. Well, that was the law until 1954. Fails both portions of the originalist test. But if you ask the originalists, they asked Amy Coney Barrett this, I think, when she was in her confirmation hearing, and she said, well, those are super precedents. That's a cop-out. That's a cop-out. The truth is, they don't fit the theory. Because the theory, it tries to make judicial decision-making into a simple, in the famous phrase of John Roberts, calling balls and strikes. If all it is calling balls and strikes, you could do that with a computer. It's judgment. And it's trying to understand the meaning of a term like due process or equal protection in the context of the time. I don't have the exact quote, but Jefferson, somebody wrote Jefferson a letter after he was president. It was 1816. And he said, in effect, to try to say that the conclusions of our ancestors are binding on us is like asking a boy to wear the same coat he wore as a boy when he's a man. He said we should not be enthralled to the opinions of our barbarous ancestors. And I think Jefferson had it right. So when it comes to, now, on the other hand, judicial interpretation of the Constitution shouldn't be just all income free. It's got to be rooted in some sense of what the Constitution says, what the terms are, what the history is, what the practice is, So I'm not saying that Supreme Court justices or other judges can just write something, make something up. But there's something between not making something up and trying to say that this is a mechanical process that doesn't that you can apply with, just without really analyzing the values. And the thing that bothers me the most about it is it doesn't allow for the evolution of ethics and values. I think we're a hell of a lot more conscious, thoughtful, understanding of values today than we were 100 years ago in many ways, in terms of things like people with disabilities, racial diversity, gender issues, and to say that we're locked in to this frozen document, I just don't think it just doesn't make sense to me. So anyway, that's as you can see, I have an opinion about originalism. But let me go back to the beginning and why do we have a constitution and why is it all broken up like this? By the way, one of the most interesting ones, here's one. This is the war power. In fact, no, this is the war power. This is a perfect example of what they did. And if you go back to Madison's notes, a really interesting reading, Madison took notes at the Constitutional Convention. By the way, the Constitutional Convention was secret, closed. They nailed the windows shut. Don't get me started on, sometimes you have to be able to debate and just, let it go. Anyway, the war power. August 23rd, 1787 was the debate at the Constitutional Convention about the war power. And they realized that they didn't want one person to be able to lead the country into war because they'd experienced that. Remember I said about history, they'd seen princes and kings in Europe say, we're going to go and have a war. So they said, we don't want that. So the Congress has to declare war. But then somebody said, but the Congress can't manage a war. So the president is the commander in chief. You see the compromise? Declare war in the Congress, manage the war in the executive. Now, one of the problems is that the president now has enormous power to commit us to hostilities without the Congress. In fact, guess when the Congress last declared war? 1942. Ever heard of Vietnam, Iraq, Afghanistan? No declaration of war. Did the president usurp this power? No, the Congress abdicated it because they didn't want to make the decision. They didn't want to make the decision, so they essentially loaded the decision onto the president. So this system that we have is genius, and it's functioned very well. But the classic quote. Apparently, Benjamin Franklin walked out of the Constitutional Convention at the last day, and a woman on the street of Philadelphia stopped and said, "What is it we have for a government? Is it a monarchy?" And he said, "No, it's a republic if you can keep it." And the history of the world is it's hard to keep republics. They tend to migrate toward authoritarianism. And Xi Jinping today says our system is obsolete, that it can't function in the 21st century because you need central decision making, you need to make timely decisions, you need to make them in a hurry, and democracy is too slow, cumbersome, and screwed up. And we're proving it this week, by the way. I mean, if what's going on in the House of Representatives is a gift to Xi Jinping and Putin, because it's a demonstration that our system can't work. And here's, I'm going to finish on this. I'll say finally. My wife Mary says I say finally too much. It makes people's hopes come up. The Constitution and the rules that have been built up are very respectful of minorities. They were worried about the majority. That's what this whole thing is about not having somebody that can abuse, not having power centralized. They wanted it to be cumbersome, difficult, slow, and they succeeded beyond their wildest. And so the problem is, have we gotten to a place where Xi Jinping is right, where we can't make the decisions and take the actions that are necessary to compete and prosper and thrive in this complex, fast-moving world? That's the issue where we are, and it brings me back to the Senate and Tommy Tuberville, where the Senate is so respectful of the rights of an individual senator that we've got a situation where one individual senator is holding up every general officer nomination, over 300 now, and really compromising our national security. Here's the problem. We have these rules in the Senate and throughout our government that respect minority rights, but it's based upon an assumption that the minority won't abuse the power that they have, that there's a sense of comity and responsibility and restraint. That seems to be going away. And that's why myself and others are talking about we got to fix some of these rules. We can't run ourselves in this way. By the way, I did a little math. The people who remember I said finally a while ago, the people who are sort of stirring the pot in the House represent 2% of the American people. Does that square with democratic theory? And by the way, the U.S. Senate would be unconstitutional if it weren't in the Constitution, because it's so disproportionately represented. I happen to like it because Maine has 2 senators and so does California. But then, I love doing these little calculations. 18 U.S. senators represent a majority of Americans. The other 82 represent the other half. Isn't that fascinating? And so the minority you want to protect minority rights, but not to the point where you can't get things done. You can't make decisions. And that's one of the problems with what's going on now, because we seem to have a group of people who don't want to make decisions, whose goal isn't a particular policy outcome, it's just to disrupt and stop the system from functioning. And I said to a friend in Washington the other day, it's hard to negotiate with someone who doesn't want anything. You see what I mean? If somebody says, I want more money for defense, and I want more money for the Department of Agriculture, that's something you can negotiate that. But if the other person says, I don't want any money for anything, I don't want to be able to make these decisions, that's very hard to overcome. So my principal message is our Constitution is an act of genius. It has served us extremely well for 200 years. It has evolved, as have our values and our belief and beliefs in each other. But it's not a lock. It's not safe. It will always take people who will administer and work within the system and make it work and respect it, and not allow us to slide toward authoritarianism, which is that's the normal path of human history. The important message is we have a genius system, but it's fragile. And it's going to take all of our commitment to maintain it and hand it off from one generation to the next. Thanks. Great to be with you. Questions? There must be some. Yes, sir.
I was wondering about your thoughts on expansion of the court in the face of what's been going on.
I'm sort of torn on that one. I don't like where the court is. On the other hand, I'm afraid if we expand the court, then the next go round, the court will expand again. We'll end up with a 45-member court. It's a dilemma. One thing I've learned in Washington is you have to always assume that things are going to flip. For example, when I first went, I was all gung-ho to get rid of the filibuster. And then some of my more senior colleagues said, wait a minute, if you get rid of it, then you don't have it if you need it. Today's obnoxious obstruction can be tomorrow's priceless shield. So, you've got to think about that, and expanding the court, so there's a Republican majority in a couple of years, and it does tend to go back and forth. Then they add 3 or 4 more seats. So I'm not sure. I don't think I land in favor of that. Others?
Chase?
Yes, Senator, you mentioned you argued against originalism because you said it prevents us from adopting and incorporating the changes in values. But we have made amendments to the Constitution to end slavery to give women the right to vote. So is that really? Oh, can everyone hear me? Okay, all right. So is that really a good argument then, given that we have amended the Constitution, and doesn't this sort of living Constitution doctrine, doesn't that kind of defeat the purpose of amending the Constitution to take into account the changes in values?
Certainly amendments, but the problem is, does that mean you have to amend the Constitution every time you decide, for example, that it's due process for a prisoner to get a lawyer? I mean, you'd end up with a 200-page Constitution. I understand what you're saying is the Constitution can be amended in large ways. By the way, it's very hard, 2/3 of the Congress, 3/4 of the states. And that should be the kind of outlet. But that doesn't allow the changes. Should we have done a constitutional amendment for Brown versus Board? And would it have passed? You see what I'm saying? Could we have passed a constitutional amendment to outlaw segregation in public schools? I doubt it. Does that mean we have to live with it? I think it's a violation of equal protection. So, and again, I tried to say, I don't believe it's open season. You can invent whatever you want. It has to be rooted in principles and values and the terms, the equal protection or due process. But I don't think you should have to change the Constitution every time there's a new factor. For example, what did the framers think about wiretapping? And is wiretapping covered by the Fourth Amendment? Of course it is. But a court had to say that. And I don't think do you see what I'm saying? You make a very good point, but I just don't think you can amend the Constitution every time there's a constitutional issue that arises under the language of the terms. Yeah. That's the argument Scalia would make. By the way, I knew Scalia in law school. Yeah, he taught at Virginia Law School when I was there, and I never had him as a professor, but I was on a board with him, and he was smart and funny, but wrong. Go ahead.
Hi. Wow. Thanks for coming to speak with us. I will try to say something coherent. You talked a lot about how human nature is innately violent, and that the framers of the Constitution understood history and human nature. And if that nature is violent, that they would understand that. And so I'm wondering how, is human nature innately violent, or is the reality that the people in power, especially during the writing of the Constitution, weren't they violent? They're all white men, slave owners, and held this elite space.
That's what makes what they did more remarkable, I think.
Well,
it took a while.
Sure. And in that, it's still kind of taking a while to break down those power dynamics. And like you said,
and the Constitution basically allowed slavery. Right. And slavery is mentioned, the famous 3/5 provision of counting people in the South. They did end the slave trade 20 years later. The Constitution ends the slave trade in 1805, I think, or something like that. Mm-hmm. But you're right. I mean, this is a really good point. And I don't have a clear answer to it. The question is, do we judge people outside of the context of their times? Is Thomas Jefferson an evil person because he held slaves? Because at the time, that was what people, that was the common, it's hard for us to imagine, but that was the life. Does that invalidate all the other things? One of the great ironies of history is the most important sentence ever written in the English language. All men are created equal. Was written on a desk built by a slave of Monticello. I don't know how to answer that. I understand your question.
Yeah, and I think in that I kind of pointed to what you were saying about how it's hard to negotiate with someone who doesn't want anything. And with those folks in power, they didn't need anything. And so it's an interesting kind of juxtaposition of.
And to make your point, as I said, they were very suspicious of having everybody vote. When the Constitution was written, it was a very limited number of people who could vote. But that's, to make my point, we've grown, we've expanded the franchise, and it took a lot of struggle. But the question is, the structure that they created is what's so amazing compared with most other governmental forms around the world, which are autocracies of some kind or another.
We have time for just a couple more questions.
So as a someone who's, I think, more progressive at least, and is interested in immigration law specifically, one of my struggles with law and government at times is, despite policies and regulation being so important, sometimes they can feel a little too cumbersome. And to what you were saying earlier, like sometimes democracy, the process does go what feels like too slow. So how do you feel, like, one, do you feel like our current system at times has created too many regulations and policies to overburden systems like the immigration system, for example? And do you think there's a better marriage or balance that we can strike with, like, being okay sometimes with deregulation as more liberal lawmakers, but also ensure that justice is being met?
Well, I mean, you're talking about deregulating immigration, but you also may be talking about deregulating trucking or the banks or the financial services. So I think, again, that's a really good question. One of my life mottos is implementation is as important as vision. And quite often people in my business feel like we're done when we pass the law, when in reality it's the implementation of the law in terms of regulations, in terms of people that are actually administering it on a day-to-day basis. That's where it really goes awry. And immigration is a perfect example where we just haven't, our laws aren't taking account of where we are today. And one of the unfortunate parts is that there's very little understanding generally about the nature of immigration. There are millions of people, and I hear them in Maine, who think we have open borders. Anybody can come into the U.S. The truth is that very few of the people coming into our country across the southern border are sneaking in, swimming the Rio Grande. They're asylum seekers. Under our law, they're legal. They're not illegal immigrants. They're legal. The problem is that system is swamped and inadequate, and it takes too long. We all know people here in Portland that are waiting for years to have their asylum claim adjudicated. So that's one of my major things. I just hired Marielle Theta from Portland to be my counsel on immigration, and she's an immigrant to Portland from the Congo at the age of 6. I think it's kind of cool to have a person that's been through the system now working to change it and fix it. So do administrative agencies and regulations go overboard sometimes? Absolutely. Absolutely. And that's one of the tensions in our system. A lot of people don't realize, you do as law students, a regulation is a law. Congress passes a law, and then the EPA passes a regulation about clean water. That's a law that has to be abided by. And quite often the agencies get out of sync with the congressional intent, and that's something we're always struggling with.
Thank you very much for your talk. I'd love to know 2 things. First of all, your general thoughts on how the speaker battle is going to come out and the impact on the looming funding timeline just generally, and then also just broadly about how we balance like making changes to the system once you're in power versus like working more on political activism to then elect the right people into the system, and how those two can work together or how they're at odds.
Okay, let me take the first one first, and I can be short on that. I have no idea. There's another. Does anybody know? How did Jordan do on the vote today? Lost again.
25.
So he's getting worse. So I don't know how that's going to come. I loved it though. I saw one of the congressmen, one of the people talking, and blamed it on the Democrats. I thought it was kind of creative. So I don't know how that's going to come out, but it does jeopardize our ability to provide, for example, funds for Ukraine and Israel and the border, and the continuing resolution that we passed 2 or 3 weeks ago expires in the middle of November, November 17th. Here's the problem. The problem is primaries. You talked about who controls and who makes activists and who. The problem is people tend not to vote in primaries, if you're in a blue district or a red district or a blue state or a red state, the primary is the election. If you get the Republican nomination to be the senator in Utah and you have a pulse, you're going to be the senator. So the general election it's not something you even think about. So who votes in the primary? And I just saw this 3 days ago. The average turnout in a primary in America is 21% of the party. Okay? And who is the 21%? On the left, it's the most activists, AOC. On the right, it's the Trumpists. And so what's happened in the Congress, and I've seen it, is that you have people that just are so far apart. But here's the real danger. I'm sorry, Dean, but I got to make this point. Here's what's really dangerous for our system, and this is something pretty new. You can now lose that primary, not because of your position on abortion or immigration or whatever the issue is, funding for the Defense Department. You can lose that election because you're viewed as someone who will talk to the other side and is not sufficiently militant. McCarthy lost because he did a bipartisan continuing resolution to keep the government open. That was his crime. Think about that for a minute. You're one of those congressmen. You're facing a primary opponent, and your sin is being willing to try to compromise and listen to the other side. Our whole system's based on compromise. I had dinner a few years ago with a very conservative Republican senator, good friend, and I said, and he was worried about a primary in a very red state. I said, Mike, how can they possibly get this right? No, it isn't who you think. I said, how can they get to your right? You're the most conservative guy here. What will they charge you with? His answer, without any hesitation, was, they'll charge me with being reasonable. Think of the implications of that for a minute. If you can lose your seat because you're reasonable, how the hell are we supposed to make the place work? And that's one of the great dangers. And I'll give you one more bit of math. In Maine and in most states, 30% are Republicans, 30% are Democrats, 40% are unenrolled. Okay? So let's say it's a Democratic primary, 30%. How many people vote? 20%. So 20% of 30%, 6%. We're down to 6% of the people at registered voters in Maine. Then you have 3 or 4 candidates. The winner gets 30%, 35%, 30% of 6%. 2% of the voters in Maine chose the nominee. That's not democratic theory. The whole idea, and the chief knows this, of getting away from, they called it smoke-filled rooms, where a few men would sit around with cigars and decide who the nominees were going to be. I contend that what we have now are just bigger smoke-filled rooms. that are still not really representative of the public. And one of the things we ought to do is allow independents to vote in primaries. And we ought to have ranked choice voting, which we have here in Maine, we have in Alaska. Lisa Murkowski is one of the very best people in the Senate. She wouldn't be there but for their open primary law and ranked choice voting. There's no way she could have won a Republican primary in Alaska. And I told her a couple of years ago, she has the highest integrity quotient of anybody in the place. So the system as it's working now militates against getting things done. And Mary always said, well, won't they put the country first? You always can rationalize, I'm going to do good for the country and I've got to stay in office, so I better not make a deal with a Democrat. And that's how it works.
Well, as we met last week to talk about what we might have this panel kind of structure around, we had no idea what Senator King would talk about. Maybe even suspect in the back of our minds that there might not be a video here subconsciously. So we picked a topic that we were pretty certain that he wouldn't talk about because I think all of us are interested in this aspect of constitutional law. And we could be pretty certain he wouldn't talk about it because it's one I think gets very little attention from the media, from the federal government, and really even in law school, right? So when we talk about constitutional law, I teach Constitutional Law 1 in the first year. Anthony has taught it as well. We really focus on the United States Constitution, the federal Constitution. When you look at media coverage of the Constitution, it's really about the U.S. Supreme Court and its decisions interpreting the federal Constitution. But there are, of course, at least 50 other constitutions in the United States that are really important, including our own Constitution here in Maine, right? Our state Constitution. And so, I think there's a lot of students, a lot of people around the country who some are unsatisfied with the current court's approach to interpreting the U.S. Constitution, and state constitutions offer lots of potential avenues for reform, for implementing ideas or rights that you believe should exist under constitutional law. So that's, I guess, the topic that I want to discuss a little bit here. And I want to start with just a really basic question. Maybe ask our panelists to just talk a little bit about state constitutions, about the promise they hold, about how they interact with the United States Constitution, and what can students do to kind of reform law or change law in using state constitutions. I don't know if one of you wants to start. I'll pass this along.
Yeah, so I'm going to speak primarily about the area that I know the best, which is environmental law. And if you've been paying attention to environmental law in the past decade, you've probably noticed that a lot of the focus is on climate change. And a lot of that focus has been on, at least from some avenues, the relative inaction of the federal government with respect to that problem. At the same time, there has been a movement to do something about inaction or lack of action on the part of all governments in state courts. And some of that activity is premised on state constitutional provisions. And in fact, there are at least 6 states, I think now 7, that have in their constitutions the right to a clean or healthful environment in some context or another, depending, the wording differs slightly between them. You may be aware of a similar effort to have that right enshrined in Maine's constitution. That is an ongoing effort at the legislature in Augusta, and through it began with a citizen referendum campaign. And then if you look outside the United States, which I won't spend a lot of time talking about just initially, there's a lot of environmental provisions in constitutions in other countries that are somewhat analogous to what we have in some states. But the one I want to just draw our attention to acutely is the Montana Constitution, because the Montana Constitution has, and for a long time had, since well before the polarization that now dominates our sort of environmental discourse, has had among its provisions a protection for of inalienable rights that include the right to a clean and healthful environment, and then goes on to provide that the state and each person shall maintain and improve a clean and healthful environment in Montana for present and future generations. And the reason I want to focus on that is not just because it's one of the oldest environmental state constitutional provisions, but also because it's the basis of what has become a very famous lawsuit over the last few months called Held versus Montana. And just to very briefly summarize what's gone on there, and we can get into it more later, Held versus Montana is a case brought by a number of youth plaintiffs in the state of Montana who are alleging that the government of Montana has violated those provisions of its constitution in not adequately addressing climate change. And the reason it's getting so much attention is because they have been successful. They are the first plaintiffs of this sort to have a judgment in their favor by a state court, and it has garnered a lot of attention. And so the point here is that all of that began with this decades-old provision in the Montana Constitution. There is not a similar provision in the United States Constitution, and it makes similar efforts at litigation much more difficult on the federal scale, and has proven that to essentially forego or forestall any similar lawsuits based on the U.S. Constitution, at least to date. Whereas we have now one example of a successful piece of litigation because of the specificity of the Montana Constitution on this one right. And I'll stop there, but just to emphasize that state constitutions are vitally important to some of these efforts that, my area happens to be the environment, but we can point to lots of other areas where state constitutions are more specific than the federal government or the federal constitution, have been changed more frequently, have different provisions, and have been interpreted differently. And it's important to recognize that they are powerful tools, both for advocacy and for litigation.
Thanks. Yes, so I totally agree with that, and want to emphasize that they have an independent vitality separate from the federal constitution, and a state court's interpretation, even of identical language from the federal constitution, can be different, can be more protective of rights. And the federal constitution is more like a floor rather than a ceiling. So there are decisions in other areas where state constitutions have been interpreted to provide more constitutional rights than are provided under the federal constitution. And I will talk about a few of those for a few minutes. On the other side, though, there can be downsides to state constitutions that I will talk about as well. But so a few examples. I mean, they can allow more rights, and they can allow different conceptualizations of rights. And a famous early example is interracial marriage, where the California court in 1943 decided, and this is actually more like a state court deciding a federal constitutional issue, which so makes it a little bit different, but it's a state court recognizing a right. They said that a ban on interracial marriage was unconstitutional. And then it wasn't until 1967 that in Loving versus Virginia, the U.S. Supreme Court held that the Equal Protection Clause and the Due Process Clause made that white supremacist law unconstitutional. There were a number of states that still had constitutional provisions banning interracial marriage for a long time, and it wasn't until the year 2000 that Alabama actually repealed its provision that banned interracial marriage, and 42% of the voters at that time said that they should keep the provision. So there is a anti-majoritarian aspect sometimes that is significant. So in the area of same-sex marriage, there's a really complicated set of dynamics that have happened that are essential in what we have seen as the foundation to the Obergefell versus Hodges decision in 2015, which said that same-sex marriage was allowed under the federal constitution. But it went way back to lawsuits filed in the 70s, and then different state constitutional provisions highlighted different facets of this. So in 1996, Hawaii's constitution had an equal rights amendment. And as you know, not every state has that. And the federal constitution doesn't have that either. And the court in Hawaii said that a same-sex marriage ban was a sex-based classification. And as such, it had to be justified by strict scrutiny. And it couldn't. It wasn't that compelling. And eventually, the Hawaii Constitution was amended to change that. And then around the same time, a court in Alaska said that banning same-sex marriage was a privacy right violation. And it was a very, creative and well-reasoned decision, I believe. And then the Alaska Constitution was amended to say, well, no, it doesn't. And then moving forward a little bit in 1999, the Vermont Constitution had a common benefits clause that was passed in 1777. And at oral argument in the Baker versus Vermont case, which was another same-sex marriage case, lawyer Beth Robinson was asked twice, why weren't you bringing a case under the federal Constitution? And why aren't you bringing an equal protection case or due process case under the federal Constitution? And she said, well, we don't need that, because our state constitution is enough. It's a source of our claims. And so we don't need to be using the federal constitution. Now, that wasn't quite an honest answer, right? Because at that time, it was still legal to criminalize sexual conduct, private sexual conduct between same-sex adults under the Bowers versus Hardwick case from 1986. And it wasn't until later in 2003 that the Supreme Court in Lawrence versus Texas said that was unconstitutional. So she made that statement. And just as a side note, she eventually was on the Vermont Supreme Court. I think Lee knows her. And eventually she was appointed a year ago to the Second Circuit Court of Appeals, federal. So after the Vermont decision, which basically said, yes, same-sex marriage is allowed under the Common Benefits Clause, because we are not allowed to kind of exclude groups using this Common Benefits Clause. And so this is kind of an exclusion of a group that's not allowed. And after that, the legislature passed a law allowing civil unions, which were equivalent in many ways to marriage, except not the status of marriage. And I think when we think of all these things in this movement and other movements, we can't sort of carve off the constitutional issues from statutory issues and other issues. So eventually, the legislature changed and said that not only we're not going to have civil unions anymore, we're going to have marriage. But that took another about 18 years for that to happen. And so there was an interaction between all the different sort of institutions, the legislature, activism, and the court in kind of moving things. And one aspect of this was the state's argument was basically no court has ever allowed same-sex marriage to be legal ever. It's not legal in any countries. This is 1999. How can it be a right? And the plaintiffs argued interracial marriage was relevant. And one of the justices leaned over and said to the state, well, doesn't someone have to go first? And then in Massachusetts, a decision in Goodridge said the Massachusetts Constitution didn't allow the exclusion of same-sex marriage, same-sex couples from marriage. And in wake of that initial decision, Massachusetts had not one, but two constitutional conventions, huge public activism, and eventually did not amend their constitution. So that decision stayed. And then there was Iowa, other state constitutions were amended and restrictions were upheld. So with all this backdrop, eventually public opinion did change. A lot of states started to repeal their same-sex marriage bans, like this state. Maine passed a very, very restrictive same-sex marriage ban, which I believe is unconstitutional. But rather than challenging constitutionally, people challenged it by going door to door and trying to get the legislature eventually to repeal it. And eventually the voters repealed it. And it was one of the first states to do that, along with Washington State. So in 2015, the Supreme Court finally agreed that there's a right to same-sex marriage under the 14th Amendment. But without this backdrop of state constitutional litigation, I think it's indisputable that just would not have happened. So that's a preliminary point. more to say, but I don't know where.
Yeah, no, great. Thank you. Thank you both. So Anthony, you mentioned kind of these newer rights, like the right to a clean environment. Here in Maine, we have a right to food now. New Hampshire has a right to privacy, and that's been debated here. There's a right to healthcare. So lots of new rights that have been proposed in various states. And then, Jenny, you mentioned kind of similar provisions of state constitutions that exist in the federal constitution, but could be interpreted really differently from the federal interpretation. I guess my question is there any risks or dangers in these rights? Because I know with the right to food, for example, there's a lot of uncertainty about what it means. There's a lawsuit going on here now about what it means. And ultimately, I suppose the state Supreme Court will have to work out the contours of some of these rights. Is there a danger to this jurisprudence of kind of creating new rights and then kind of hunting to the courts to determine what those rights mean?
Yes.
How do you think of
No. Yeah.
the right to food?
So let's talk about. I mean, we talk about the right to food, but I think the Pine Tree Amendment, the right to a clean and healthful environment, which is that's the campaign in Maine, is an even more illustrative example, because if you look at who's supporting that amendment and who's against it, you can find environmental groups on both sides. And one of the reasons for that is that there's some belief, and it's not unfounded, that these amendments provide a vehicle for litigation that will stop activity that we need to happen. And in the environmental context, that's primarily clean energy development. And the argument is that, everything that we do in terms of development, and pretty much all of environmental law is always a question of trade-offs. And when we're talking about clean energy development, we're building new infrastructure. Something is going to have to be is in the way. We're going to build it somewhere where there isn't something now, or where there was something before that we're tearing down, and there's going to be environmental impacts. And so one of the primary arguments you hear against these type of environmental rights being recognized in the United States is that if a state puts it in place with this very broad language, you're going to have opponents of clean energy development challenging every permit in state court and saying it violates the Constitution to allow this wind farm to be placed here because it hurts the fish or the lobster or the birds. And those are all part of the natural environment, unquestionably. And if you have a right to a clean and healthy environment, how is the environment healthy if birds are dying? I mean, that's the argument, right? I'm kind of a little bit simplifying it, but that you can see how the argument would be made. And especially in a state like Maine with a relatively, I would say, relatively speaking, a low volume of cases, right? There's not a lot of case law that's going to support this. The arguments, everything is novel. It is unclear how the court would come out on questions like that, what kind of balancing tests they would inevitably fashion to decide whether something violated one of these broad sweeping rights to food or to the environment. And perhaps that time that it would take and then the tests that would be employed would actually result in less getting done, is one of the arguments that you hear quite often. And just to go back to the right to food, you see in clean energy, you see this being already argued with the right to food and clean energy with respect to offshore wind development and similar projects that theoretically endanger wildlife that people capture for food. And so, that's problematic if you are in favor of that development. And you might argue that stay away from these constitutional amendments, because if you want clean energy development, you should just push for that as a legislative and regulatory solution and forget about amending the Constitution, because you don't know what the negative consequences might be. I'm not ascribing to one side or the other of this particular argument. I'm just laying it out. That is the argument, and it's a legitimate debate. And the answer is not clear what the result is going to be, and that makes it even harder to decide. It's because these areas of state constitutional law are so novel. There's no guarantee that the Maine court is going to interpret our right to a clean environment the same way that the Montana Supreme Court interpreted their right to a clean environment. There's no precedential value in that Montana Supreme Court decision. It's just instructive or persuasive at best. and we could interpret it as Professor Reagan suggests, the same language entirely differently, and there could be negative consequences for that. So, and that goes for any number of these articulated rights, often because they're articulated in language that is very broad and sweeping in some instances, particularly when you're talking about environmental rights. And the right to food is a great example. I mean, the right to food, if you read the provision, is quite expansive, or you could interpret it quite expansively.
So if you're a budding lawyer, it's going to be a source of thousands of billable hours, I would say.
Or it could be the subject of a topical issue for a law review, perhaps.
Yes,
yeah, where
yes.
a lot of interest in the articles would come about.
Yeah, a lot of great issues under state constitutions. Both of you, we focused on rights mostly so far for the first half hour, but let me just ask, both of you raised kind of a structural issue. I mean, one is that state constitutions are a lot easier to amend, right? So you both mentioned kind of the referendum process. It's especially true in kind of West Coast states, but Maine is unique, at least kind of east of the Mississippi, where we have an initiative process. But if you live in Oregon or Washington, or really almost anywhere west of the Mississippi, there is a pretty strong constitutional tradition, and you go to the ballots and you vote on oftentimes dozens of new constitutional rights or issues in the state. So I guess I just want to ask you generally, kind of give your thoughts on the different structures that exist in state constitutions, either in the amendment process, which is much different than the federal constitution, which is almost impossible to amend, or the different structures of government. So for example, most state judges are elected, right? So we focus so much on appointed judiciary at the federal level, but that's not the case at the state level. Of course, state AGs are generally elected. In Maine, it's unique. That's kind of elected by the legislature, but there's different sources of authority and power in the AG's office and the governors who sometimes get disputes. So there's kind of unique separation of powers issues that arise in state constitutions. So I just want to give you a chance to talk a little bit about kind of structural issues and what's unique about state constitutions from that perspective, kind of different than rights.
One thing that's striking is that justices of state Supreme Courts are, I believe, more easy to get rid of and vote out of office. If they're elected, they can be recalled. And there have been, some really high-profile examples of that early in California. Rose Bird, the Chief Justice of the California Supreme Court, was recalled several decades ago because she was consistently opposed to the death penalty, and some justices in Iowa who voted unanimously in favor of same-sex marriage were voted out in 2010. Then in 2012, one of them actually was not voted out. They tried to in one re-election, sort of as public opinion changed. So they can be closer to public opinion than the Supreme Court, certainly. And that's, that's a different aspect to it. Most of them don't have life tenure. I think 45 states don't, and most of them, I think, have term limits. And I think Massachusetts, New Hampshire, New Jersey don't have term limits, but justices are supposed to required to retire at age 70. So, different regulation of state Supreme justices who would be interpreting the state constitution are I think significant. And yeah, I mean, I think the ease of amending state constitutions can be kind of a double-edged sword, right? I mean, going back to the early 20th century, after the 13th, 14th, and 15th Amendments were passed, which were supposed to, among other things, like allow Black men the right to vote, states in the South, like Alabama, amended their constitutions to say that have things like poll taxes and literacy tests and grandfather clauses. So if your grandfather hadn't voted, you couldn't vote. And that just made the number of Black voters go from 180,000 to 3,000. And so that was incredibly effective at keeping Black people out of the legislature and out of the voting booth for the next until 1965. So, and the Supreme Court, with such luminaries as Oliver Wendell Holmes, upheld those restrictions without exception. And so this was sort of old impact litigation. I think, some of us think, well, impact litigation just sort of started with Brown versus Board of Education, that kind of thing. But it actually has been going on for a very long time, and efforts made repeatedly to get, you know, broad decisions that would establish rights. So it's hard to generalize with some, you know, big statement about it, but it's a two-edged sword, I think, in terms of that sort of closeness to politics, really. Yeah.
I'll just say one thing, and that's it's semi-structural, and it's access to courts. And most of you are familiar with at least the idea of constitutional standing under Article 3 of the Constitution, and how that stops some litigants from accessing the federal court system. Well, state courts have standing doctrines as well, but some of them are more permissive than the federal standing doctrine, which creates a situation where you might be able to access the court system more readily to vindicate your rights in state court. And that is an interesting experiment. In some ways, it's also just an interesting feature of sort of state design, separation of powers. It's a different way of thinking about it than our federal standing jurisprudence, at least has been to this date. Many states' standing jurisprudence mirrors the federal jurisprudence, but that's not all states are like that. And that is, in environmental law, it can be a very important thing to know, because often environmental litigants are confronted with standing issues. And so that's just one aspect where you can point to a marked difference, and it is somewhat structural in the sense that that under more permissive standing doctrine, you in those states, you have court systems that are handling more issues than in states with more restrictive standing doctrine.
In fact, in Maine, advisory opinions are permitted, right? So you can ask the court to give you an advisory opinion on a constitutionality of a legal issue, which is kind of black letter law that you can't do that in the federal system. Yeah. Okay. Well, I think we plan to do this for about 20, 25 minutes and leave some room for questions. I don't think we're going to get a video here, so I do want to make sure there's some time for questions. But, you know, I think one kind of general point I want to at least as a takeaway is this is a really exciting area, and you know, with the new rights, it might sound like it's, you know, kind of a newfangled area of litigation, but of course, state constitutions have been around before the U.S. Constitution, right? The federal constitution is modeled after Pennsylvania's and Massachusetts and other constitutions that were in place at the time. The state constitutions were the source of many of the rights that are recognized in the federal constitution. They're pre-existing rights that existed in the states. So it's an area of law that existed for a long time. And there's some great sources of authority for you as an attorney to take a look at the exact same language in the Maine Constitution or the Massachusetts Constitution that it's based on, and say, you know what, our version of the Fourth Amendment means something very different than the U.S. Constitution's version of the Fourth Amendment or the Eighth Amendment, cruel and unusual punishment. If you don't like how the Supreme Court interprets it, you can make the same originalist historical arguments looking at what our Constitution means, right? And the exact same words might have a different meaning here in Maine than in the federal Constitution. So as an attorney, I think it's like, you know, the skills that you learn in Con Law 1, even if you focus on the federal Constitution, they're the same skills you would use to make an argument under the state constitution, which gives you a kind of a second bite at the apple or a whole new way to argue a meaning of a constitutional provision. Any questions that you have? Any thoughts on things we talked about?
Yeah, thanks for everything that you guys have shared so far. This has been kind of interesting to walk through. But one thing I'm curious about is we're in this period, this kind of unique period in American history where it's been like over 40 years since we've had a constitutional amendment ratified nationally. I'm pretty sure that's like the longest in our country's history. Can you speak more to that and what that kind of means in terms of the progress of civil rights or just other sorts of constitutional rights that are afforded to Americans, and maybe why that hasn't been happening so much lately, like why we haven't been passing more constitutional amendments?
So I don't have a political science answer necessarily. I mean, maybe 3 or 4 years ago, Professor Rafa and I kind of debated this idea of a second constitutional convention, right? So there's in the Constitution, there's 2 ways to amend the Constitution. One is kind of following the standard process and getting 3/4 of the states to agree on something, which, you know, just seems so far-fetched today when there's so much disagreement about the very basic ideas, concepts. We're so divided. And there has been this movement to call a second constitutional convention And so we debated about kind of what that would mean, what it would look like, what kind of rights would come out of that process, right? And as Professor Riggins mentioned, with kind of referendum initiative process, it has a similar pros and cons, right? You might identify rights that are responsive to majorities, to people today. Maybe you like that, or it might be rights that many of you would disagree with, right? So there's a lot of dangers in something along those lines. But yeah, I think with how divided the country is today, the process the way it was created made it very difficult once the country's divided to have any kind of new rights be recognized. And even things that, if we were behind some kind of a Rawlsian veil of ignorance, we might agree that, a certain idea from 1787 or 1789 makes no sense today. They all benefit one party or the other now, right? And so when you're in the winning side, I say, you know what? We like the Electoral College. It benefits us. If you're on the losing side, you don't like it, right? And so I think because amendment process is so difficult, now somebody might say, well, that's a pro, the stability of the law, right? Consistency of the law. But, I tend to agree that making it so difficult to amend makes it a very kind of anti-majoritarian, counter-populist type document. But I think because the process was made so difficult, I think it's unlikely we'll see those kind of amendments. And that's why I think the more federalist approach, where you can recognize new rights, and we talked about the rights that are more identified with the left, but it doesn't have to be that way. You can have economic and libertarian type rights that are identified, Lochner era rights, if you've studied Con Law 1, be recognized in some states as well, right? So it gives an opportunity for states to recognize rights that are more responsive to the people and are, kind of more relevant to the people that live in that state. I don't know if anybody else has thoughts on kind of the amendment process.
I would say that arguably some of our schools of constitutional interpretation have been born out of the fact that our Constitution is so difficult to amend. And for better or worse, that is where we are. And I don't know what the answer is whether or not we'd be better off, but I do think that it's useful to engage in comparative constitutional law and look at other countries that are designed via a written constitution. Not all countries are, but many are. And some of those constitutions are much easier to amend than ours. And you can learn from those experiences, and you can see the pros and cons playing out in those systems of government and their courts. And you can judge for yourself whether that would be a better system or not. But I think our system is, by design, very difficult to change.
Good question. Others?
I was wondering if you would maybe comment on a graduate of this law school, Representative O'Neill, just put forth legislation a few years back about information privacy. And while it's not necessarily constitution, it's sort of addressing, issues of rights through state law to sort of try to guard individual privacy a little bit better. Do you think there is a role for that, or do you have any comment on what's happened since that law came in place?
If any of you have any knowledge,
I don't know enough to comment on it.
I know a little bit about it. I would say, all I'll say is that I think, as Professor Riggins pointed out, that we have often pursued the protection of rights via legislation when the constitutional route is difficult or doesn't yield fruit, or for whatever reason, right? I think I'm not, like I said, super well versed in exactly the campaign for that particular set of rights in our state, but I think Dean Baum pointed out that in some states there are constitutional provisions that do just that, including in our neighbor state of New Hampshire. And so it is an interesting question, and it would be an interesting question to ask the people behind these movements or these initiatives why they chose legislation versus a constitutional amendment. And I don't know the answer to that. It wasn't mine, but I do think there's probably some strategy in that, I would anticipate, but I don't know.
Yeah, I mean, from my perspective, I looked at New Hampshire provision. We just said something like, the right to privacy shall be held inalienable in the state. And, I'm not sure what that means, right? I'm sure what it means for the Fourth Amendment purposes. I'm sure what it means for search warrants. right? So my general preference is if it's in legislation, you can actually write the details of what the law is and regulate different industries in a more granular way. When it's written at a very high level, it does open up the door for more interest groups to make arguments that support their view, but it does raise a concern for me about, who makes a decision about what does the word privacy mean in that state constitution. Anybody else?
Hi, thank you so much for all speaking today. I really appreciate hearing a little bit more about this and learning a lot more about this topic. My question, and forgive me, I guess, for not having it as well first, but hopefully I can communicate well, is I know these days there have been a lot of constitutional and civil rights that have been at risk and that have been attacked, especially in the past few years, even though we've made great strides in the past few decades with those same rights. And there's been very clear partisan issues and, lobbying that's influenced judicial decisions that are supposed to be, prided on the fact that they're objective and it's supposed to be an objective field and everything for the greater good of the country. How do we go about trying to remedy and trying to bring back more of that objectivity to ensure that everyone's rights are being upheld and no one is really, I guess, being discriminated against as much as we're seeing it happen now? That makes sense.
Are you a 1L?
Yes.
What's your name?
Erin?
Erin. I don't want to give you too cynical of an answer because we haven't studied con law yet, but I guess I would say for a lot of the issues that the court faces, the U.S. Supreme Court faces, whether it's right to same-sex marriage, right to abortion, affirmative action, they're interpreting three very due process of law. What does that phrase mean? Or equal protection of the law. Or arms or bearing, right? What do those words mean? Whatever kind of the issue that you disagree on, I would say there's no real objective way to say clearly the word bear means you have a right to have a gun in your house. There's just not a definitive answer on any of those things, and same thing true with due process. So that's where I would say, that's why I picked the topic, and we chose the topic for today, really focusing on state constitutional law, where it feels like you can actually make more of a difference in passing rights today, passing constitutional provisions today that we can sort of agree on what they mean and put some details into them. Because if you're relying on the U.S. Supreme Court, look, you're going to be on the winning side for a couple of decades and losing side for a couple of decades, because nobody can say look at the dictionary and know what those words mean. So I would say it's impossible, right? What the court is doing, what the U.S. Supreme Court is doing, is a lot more politics than kind of what I thought of as law before I was a law student, right? I think trial courts, do a lot more of that, like what we think of as lawyers or judges doing, where they're looking at facts, trying to apply a lot of those facts. But if you're trying to figure out how does due process of law apply to abortion, you're not going to find an answer, or you can find kind of whatever answer you would like to find using different methods of interpretation. There's other thoughts.
I'll just say that it's important when you study con law to pay attention to what the tools of interpretation are. If you care about amending the state constitution, likely those same tools of interpretation are going to be used to interpret the amendment that you put in place. So paying attention to the record that you build and how you go about amending it might be relevant to how those words get interpreted later. And we have, with contemporary amendments, we have the benefit of taking that approach. We don't have the benefit of rewriting history and adding to the history of why the founders or the framers changed the Constitution in the way that they did. But we do have the benefit of writing and documenting why we're doing things now. So just as a matter of sort of looking forward, that's what I would counsel.
And I would just add, to echo sort of what I said before, and also what other people have said, is just, I think it ends up being a dead end to just think about the Supreme Court, and that, state Supreme Courts are really important, like we've been talking about. I think just looking at constitutional law, whether state or federal, is also can be kind of a dead end. So like looking at other aspects like, torts, for example, can do a lot in terms of, changing things. Not as much as one might like, but, other civil law topics can do a lot, and also sort of institutional changes in terms of who's making the decisions and things like that. And also just going way beyond cases, practicing to the legislature and agencies and towns and cities and all those things where decisions get made, school boards, everywhere, because law in a way is everywhere. And so one can work on it at any level that you like. And then also just beyond that, sort of community engagement and things like that. So that's, just trying to broaden the approach, I think, is what I would want to focus on and recommend.
Anybody else? Okay, well, great. Well,
I'm just going to just say, can you describe some of the different methods that Supreme Court justices use when looking at these questions of law that make it up to that level, or at least your perception of them?
well, I guess I promised a little spoiler of Con Law 1, right? Which is really how I structure Con Law, and I think the way Professor Bloomberg does as well, right? Looking at the different tools of interpretation, different tools that you can use as an attorney, even if you're not a constitutional lawyer, right? So, obviously the court right now focuses a lot on history, right? It's kind of original understanding or original meaning of those words, traditions, right? That's an important tool. But certainly looking at the text, looking at the structure of the document, looking at making a policy type argument, or understanding the policy or the consequences of a certain approach. Now, certain of those appeal to different justices, right? From different backgrounds. But, if you're a good attorney, you're going to be able to make an argument based on all of those tools. You might say, like, here's some history pointing this way, here's some history pointing the other way, but here's the consequences, utilitarian argument almost, of this approach versus this approach, right? Here's the policy on one side or the other. Here's the structure of the document, understanding how it's connected to other provisions of our Constitution or our legislation, right? So there's, a lot of those tools are similar to what you would use in a statutory interpretation context as well, interpreting statute, right? But those are the tools you would bring to bear in a constitutional case as well.
Sure. How do you think the differences in how the state constitutions are amended versus the federal constitutions are amended or ratified? How do you think that plays out into these different judicial interpretations of the state Supreme Court versus the U.S. Supreme Court? Because on our national Supreme Court, if you went to Mr. Shapiro's lecture on Thursday, only about 10-15% are on conservative liberal ideological lines. So do you think that's more or less than in state courts?
I think it depends maybe on the state and the issue, right? So, many state Supreme Courts have mandatory jurisdiction over some cases, right? And so there's going to be a lot more non-controversial cases because the court had to hear those cases, where the U.S. Supreme Court picks and chooses its cases. They can pick the issues that they're kind of most interested in, right, with the cert process. So that's a little bit different at those levels. But, kind of tying back to the both the populist process of amending the Constitution and the populist process of which judges are selected. I mean, certainly if you're a justice on a state Supreme Court, you're more closely connected to the people, right? Now, you might say that's a good thing or a bad thing, right? We can argue kind of independence versus accountability, but I think those justices who either have to be elected to get their job or have to be re-elected to keep their jobs, they feel more empowered to reach decisions that are more aligned with the populace, either empowered to do so or might feel handcuffed to do so, right? So there's been quite a few studies looking at decisions in most states. And like I said, Maine is unique, and actually New England is unique that we don't elect our judges, but throughout the rest of the country, that's what happens. And you do see judicial decisions are more closely aligned to majoritarian preferences, right? And that would probably be true in constitutional interpretation of new amendments, right? New rights that are popular with current majorities in that state. Now, the other kind of risk with that is they're often more aligned with the contributors, right? Those who gave the justices money, the money they might need to run for re-election, right? So there are certainly pros and cons and kind of major consequences of an elected judiciary. But in a state that takes a more populist approach, that's what I would expect to see. And that's what numbers seem to show, that decisions tend to align a little more with majoritarian preferences.
Thank you.
Yeah. Okay, well, thank you all for being here. I know it's a kind of a late afternoon.
I have a quick question.
Oh, yes.
I didn't want to forget for wrapping up on time. I'm just sort of wondering generally about sort of the interplay between these like state level efforts and the national effort, and how you think one influences the other. And I'm sure there's a lot of sources of, like in the national media, you hear about some of these, like in California, there's a lot of these sort of ballot initiatives that happen. But I personally am from Washington, D.C., so I have very little experience with the state constitution amendment process, and everything is based on the federal government and how that's interpreted. And so I'm just curious about how you think one can influence the other, and if those sorts of initiatives are, I guess, a good way to gain sort of national support or political support for a movement, as opposed to just general political activities, if that makes sense.
Yeah, it does. I don't know if you have thoughts on kind of how the process actually played out here. I had not heard of, for example, something like the right to food have any kind of national, either Democratic or Republican support, right, or coordination. Right now, of course, I mean, the parties are significantly stronger. The framers could envision the party system that we have now, right? So a lot of the, today you can have parties at the national level aligned with state level and kind of put a bunch of money behind a certain policy. So you can imagine a lot more of that. But I'm actually not sure if anybody's kind of studied how much coordination has happened on some of these kind of newly recognized state constitutional rights, or if there's a close alignment with kind of national party preferences with the state. So I don't have a definitive answer. I think there's certainly opportunities for that, given the power of the parties as organizations. But as I think about some of these rights, I don't know if they closely align with kind of one political party or another. And they seem to be kind of more representative of local interests, setting aside party preferences, but I don't know for sure.
Yeah.
Yeah, I mean, just a broad historian. Have you come across Theda Skocpol? She's a historian, social scientist who did research on this. Not exactly this, but sort of the issue around how change happens broadly in sort of politics in the US. And she did a lot about the Civil War, Freedmen's Bureau, and also when benefits started to be given, like in the early 20th century, like at the time of Teddy Roosevelt. And her first thesis was it started in Washington and it sort of spread out. And then she realized when she did a lot of archival research that no, it was sort of the other way around, that it started in the States with little efforts that kind of gelled a little bit and then gelled a little bit. And eventually it came to Washington. And so that's sort of the way she thinks about it. And she thinks a lot about political change. She is based in Maine. But I don't know that like can be transferred to like the 21st century and things like that. But it's sort of an interesting way of analyzing and understanding some of these things.
But I think your same-sex marriage example is a kind of a good example of that sort of playing out, where there's, I mean, a lot of people were thinking about, what is the right way or the best way to kind of approach this issue? Is it litigation at, under the federal constitution, state constitutions, right? And so, you can certainly, if you're into kind of politics or thinking about grassroots movements and how to implement change, you can think about it at the national level, how to start a kind of small scale in the states, and then convince the people, hey, here's an approach that has actually worked, right? If you think about the classic arguments for federalism as laboratories of democracy, right? Experimentation. Well, state constitutions are a way to do that, right? You can have a laboratory and play out, okay, let's see how this right works in a certain state, and if it doesn't, we can learn from that. All right, again, well, thank you all so much. I know it's late. Grab some donuts on your way out of there, some left over. Good luck the rest of the semester as well.
Thank you. Have a good night.